Hello, everyone. We are happy to start our final webinar within our Business and Human Rights Spring webinar series conducted and organized within BHR Mentorship Program for Early Career Researchers in Ukraine. And we will record our session and admit more participants soon. We have three outstanding speakers for today who will present on the topic of platform workers and their rights, which is the topic of today's webinar. And our first speaker is Angelica Bonfanti, who is associate international law at the law faculty of University of Milan. Also, we have Terreros, who is a doctoral candidate at the Graduate School of Law of Basel University, a PhD in psychology from Universität, the País Vasco, and a Master of Science in Industrial Relations from London School of Economics. And also, finally, we have Kateryna Shapovalova, who is a PhD researcher at Yaroslav Mudryi National University and digital society initiative at Zurich University, and Kateryna also is a mentee of our program for early career researchers on business and human rights in Ukraine. We will have the following program. So first we will have our three presentation. Each will take 15 minutes. And then we will proceed with an open discussion with the audience. So please free to raise your hands during the discussion or put your question in the chat. We will be happy to elaborate and discuss further. And I think we can proceed to our presentations. And Angelica will present on digital labor platforms in a BHR perspective, a focus on strategic litigation. So Angelica, the floor is yours.
So thank you very much for the kind introduction. I'm very happy to be here. I'm grateful for the invitation, and I'm first of all grateful to be on board in such a great project. So thank you very much for having me on board. My focus, the focus of my presentation, as you have already announced, will be on the digital labor platforms in a BHR perspective. And I will mainly concentrate my attention on the case law. So just few premises on the importance of this issue and on the main legal aspects that emerge from the case law and from the most relevant developments in the legal frameworks. Workers in the digital labor platforms are particularly exposed to human rights violations. And this depends on several legal factors. First of all, they tend to be characterized as self-employed, which means that under the legal system of several states, these workers do not have social security, do not have social rights or have limited social rights, and can be fired without any specific guarantee. Moreover, they are provisional workers. Often they are migrant workers, and therefore we can overall consider them as vulnerable individuals or groups. The economic conditions they face when working, for instance, as riders employed by the digital labor platforms, the economic conditions are extremely impactful. They often live in a poverty condition. They have been classified as one of those areas where poverty, extreme poverty arises, and this is the classification given by the UN Special Rapporteur on extreme poverty, for instance. And this condition is even worsened by the fact that often these workers do not have the possibility to join trade unions and being collectively represented by trade unions. So given these specific circumstances, these workers face important risks, including the risks to be exploited as forced labor workers, to be pushed into intolerable rhythms and pressure, and to be subjected to unfair labor conditions. Given this overall framework, I think that the business and human rights approach might be considered as an important tool in this specific area. As we know, the business and human rights framework funds its basis, its foundations in the UN Guiding Principles on Business and Human Rights. The UNGPs provide for 3 pillars: the state duty to respect human rights, the corporate responsibility to respect human rights, and access to remedies. Now, I will mainly focus my reflections on the second and the third pillar. Therefore, I will mainly focus my reflections on the corporate responsibility to respect human rights and on access to justice. Now, my point of departure of my reflections is that the digital labor platforms should be subjected to the same treatment as all other corporations, which means that they must respect human rights within their economic activity, and that the workers as victims of human rights violations, of considerable workers' rights violations, which amount to human rights violations, shall be given the right access to remedies. Now, all these reflections are coupled with the specificities of the area we are looking into. The digital labor platforms are not completely comparable to the different corporations such as the textile or the extractive companies. Digital labor platforms present specifically characteristics which shall be taken into account and which deserve being highlighted in their specificities in order to address correctly the protection of workers. To this extent, I think it is preliminary to delve a little bit into a comparative approach among the different legal systems around the world, or at least among the main differences we can encounter within these different legal frameworks. So I will make an example focusing on the directive, or the European directive on the digital labor platforms, which was adopted by the European Union as to grant the workers in the digital labor platforms some specific guarantees. And the main outcome of this directive is to establish the duty on the European member state to introduce within their legal system a presumption according to which the workers employed in the digital labor platforms shall be considered having in place an employment relationship with the corporation. So they shall not be considered as self-employed workers. Conversely, they shall be considered as employed, having an employment relationship in place. From this characterization, several workers' rights descend, including social security and the right to be given certain guarantees which are specific on the condition of employed workers. So according to the directive, all the European member states shall introduce within their legal system a presumption of the existence of an employment relationship for the workers employed in the digital labor platforms. Now, this is a very important step in the direction of granting the workers a higher level of protection. The European legal framework is not completely uniform in this regard. For instance, in December 2023, the Hungarian Supreme Court, as before several years ago, the Supreme Court of Hungary has recognized in a specific case that the worker who was complaining about the mistreatment by the digital labor platform sued in front of the Hungarian tribunals. The Supreme Court concluded that that worker was a self-employed worker. So disregarding all the claims for social security proposed, subjected by the worker in front of the court. And the analysis of the Hungarian court was based on several practical factors occurring in the specific circumstances of the case. For instance, how the work was organized, how the working time was organized, the remuneration granted to the worker based on the number of the deliveries and on a fixed percentage on them. Therefore, several factors which concretely led the Supreme Court to conclude the plaintiff, the victim, not victim, therefore the worker, was a self-employed worker who did not deserve specific guarantees. Therefore, the conclusion is that despite the provision for the introduction of a presumption for the existence of an employment contract between the workers and the platforms, the analysis in the concrete cases, again, can lead to different conclusions in the specific circumstances, such as the case I was bringing to your attention. The issue of the characterization of the employment relationship is not specific only to the European Union. For instance, recently, Mexico has adopted a specific amendment to the federal labor law to uphold the labor rights of the workers in the digital labor platforms. According to this amendment, the workers shall be classified as employees, so no more self-employed workers, but employees, when their monthly income exceeds the minimum wage. Therefore, if they earn a certain amount of revenues, of income monthly, they shall be considered as employed by the digital labor platforms, with the legal consequences in terms of social rights and social security, which derive from the characterization as employee. Now, coming to the overview of the case law, hundreds, thousands of cases have been filed against the digital labor platforms around the world. I will focus on the Italian case law, not only because I'm Italian, but also because it is very representative. I mean, my analysis shows that the Italian courts have several times examined the specific legal issues concerned with the protection of the workers in the digital labor platforms and have led to considerable outcomes in terms of granting the social security, the social rights to these workers. Just to give you an example, in 2023, the platform Uber Eats and Deliveroo have been convicted by the Italian courts and obliged to grant the social security to the workers. In 2023, Uber Eats was instead considered responsible for the unlawful firing dismissals of 4,000 riders, and therefore was obliged to adopt the measures which the law provides for the cases where a worker is illegitimately fired. Again, in 2022, the Italian courts ordered Glovo, another digital labor platform, to reintegrate a rider which was fired because disconnected and without respecting, therefore, the specific conditions established by the platforms, conditions which are considered inconsistent with the law. In 2022, the platform Fudigno, Glovo, was instead considered responsible for the lack of grant of social security to the workers, and therefore obliged to apply the national collective agreement to the riders. This demonstrates that a trend in the case law is developing, a trend favorable to consider the riders as workers having in place a specific employment relationship with the platform. And the characterization of the worker as employed by the platform itself, as you have seen, leads to the concession of specific social rights which are characteristic of the employment relationship. Now, the last case I would like to bring to your attention is a case settled by the Italian courts in 2023. The case concerns the identification on the part of the court of some practices of forced labor. Exactly, it's a kind of modern slavery that we call caporalato within the activities of Uber Eats in Italy. The Italian court has recognized that Uber Eats was perfectly aware of the fact that the company Flash Road City, which is an intermediary that practically employs the riders for Uber Eats on behalf of Uber Eats, this company Flash Road City did employ a crew of riders and did provide these riders with treatments which are inconsistent with the basic workers' conditions, thus paying them with an income of €3 for delivery, and often less than €3 given to some punitive approaches that the company did implement with the workers, and forcing the workers to accept hundreds of deliveries in order to have some more revenues during the day, and pushing them to inhuman rhythms, let's say, during the day again. Therefore, putting the workers in the condition of modern slavery, which is called caporalato. Now, according to the reading given by the Italian court, despite the fact that the relationship with the riders was managed exclusively by Flash Road City, Uber Eats was shown to be perfectly aware of the treatment given to the riders by the company Uber Eats itself had employed as to create the crew of the riders who are employed, let's say, by the platform itself to perform the deliveries. And this awareness on the part of Uber Eats was considered as a crucial element in the reconstruction by the court. Based on these conclusions, the court convicted both the director of Flash Road City and the director of Uber Eats, considered as responsible for their implication within the specific mistreatment of the riders. Now, if we try to read this specific judicial decision through the tools of the business and human rights approach, we see that in this case, the victims have had an access to justice, and the case has been brought to justice and has led for the victims to a satisfaction. The case is a criminal one. Therefore, the fact that the directors have been convicted represents something considerable, and the victims might in the future obtain compensation as with the civil responsibility connected to the criminal one. On the other hand, my impression is that the conduct put in place by Uber Eats was aware of the fact that the other society, Flash Road, implemented these kind of practices, these kind of mistreatments against the workers. And Uber Eats not only was aware of this fact, but somehow took profit of this, or at least did not put in place any measure as to avoid it. This conduct on the part of Uber Eats is exactly the kind of conduct that the human rights due diligence tools, the establishment of which is required by the UN Guiding Principles on Business and Human Rights and by the Corporate Sustainability Due Diligence Directive, for instance, is exactly the conduct that this instrument wants to prevent. Therefore, my impression is that the reading given by the criminal courts in Italy is perfectly aligned with the idea, the concept of human rights due diligence, and somehow is a reading that is aligned with the trend of introducing human rights due diligence tools also in the digital labor platform. So I'm available, obviously, for answering any questions, and I will be happy to listen to the presentations of my colleagues. Thanks for the attention.
Thank you so much, Angelica, and it's really indeed illustrative of how all this liberal model is working in practice. Yes, allowing businesses to approach workers in such a wide way, not being sufficient with binding regulations on businesses, but we will discuss more during our discussion panel. And now I would like to give the floor to Julian, whose presentation will be on digital labor platforms and the substantial modification of working conditions, which we are very happy to listen to. Julian, the floor is yours. Yeah, I'm sorry, you're muted. Oh, great. Yeah.
Okay.
Yeah, now it's working.
Can you hear me now?
Yes,
Yes, we can.
Okay, thank you. So thank you, Tamara and team, for inviting me to participate in the webinar. And yeah, I'm very glad to be able to discuss with you all this critical topic in our current employment law landscape. So I will focus my intervention on the substantial modification of working conditions. And yeah, let me share a short presentation. Maybe you should activate.
Yes, I already allowed everyone to share the presentation.
Okay, good. Hopefully, you can see. Can you see now the presentation?
Yes, we can see it, but still not in the presentation mode. So maybe.
Okay. Is it working now?
I think we still see it in the PowerPoint, but we don't see it as a present in mode.
Okay. Well, I'm seeing it myself on a presentation mode in my screen. Well, if you have any difficulty in reading in the screen mode, just let me know. So I will cover briefly each of the different topics since we have 15 minutes. I will start with an introduction and characterization of platform work and digital labor platforms. So this is a phenomenon, the labor platform economy, that refers to digital intermediating companies connecting labor via apps, so via software, special software that emerged after the 2008 crisis and focused on the provision of services such as software development, transportation, and delivery of goods and services.
I'm so sorry, Julian. I just think we don't see your slides, the next ones. We only see the first one with the title of your presentation.
Okay.
Yeah, now we see it.
Is it better now?
Okay. Yeah, now it's
Then
working.
I will go through the slides in skim mode. So as I said, so these type of services that are provided via digital labor platforms are mainly related to software development, transportation, and delivery of goods and passengers, and a wide array of service that can be provided online, like software development, translation, etc., or as well on location, like delivery of food, right, in urban environments. Examples of these companies would be Uber, Glovo, Foodora, Upwork, and so many others. The characteristics of platform work as concern the employment relationship are mainly, these are based on a triangular relationship involving the customer, the platform, and the worker providing the services. We will go later in detail, as Professor Bonfanti did already, when the provider of the service is actually an employee or is simply a self-employed person without an employment relationship, right? The second characteristic is that the management of the service is performed through an algorithm, a software that controls the provision of the services, the allocation of tasks, etc., etc. Typically, the platform work is task-based. Pay is related and calculated for a specific task performed in various small units. And also the ambiguity of the employment status. Probably this is the most important characteristics as concern the employment relationship. So there are several elements to consider related to the protection of rights of workers in this type of economy, platform work. Typically, rights, employee rights or workers' rights are undermined by misclassification. As we already discussed, Professor Bonfanti mentioned as well, workers tend to be classified or rather misclassified in some cases as autonomous workers, self-employees, or whatever the category that may not correspond to the reality of the provision of the service. Rights affected by this classification are important rights of the employment relationship, like those concerning wage, safety, bargaining or representation rights, etc. And we are seeing an increasing level of global and regional legal responses, which I will come later to this point. I think is critical to really ensure that the protection of the rights of workers is maintained. Main challenges in the regulation of platform work are first the transnational nature of the work itself. So this provision via an online tool and app make very easy for companies to extend their operations across multiple countries with different jurisdictions and legal frameworks. There is also an important element that is the opacity of the algorithm. So, and this is addressed, in fact, deeply by the European directive that Angelica mentioned a few minutes ago. And two additional characteristics are the weak enforcement against violation of employees' rights or workers' rights, and the weak representation, the weak nature of collective bargaining in the very limited cases where there is some kind of collective bargaining within the world of platform work. Some opportunities connected with emerging regulation. Well, first, the European Directive on Improving Working Conditions in Platform Work from October 2024 addresses as a key element the presumption of employment in the relationship between platform workers and the operating companies. And this presumption that Angelica also referred to is critical because the burden of proof displaces from the worker to the employer or to the company hiring the worker, whether it is allegedly through an employment relationship or not. There are some other European legislation, some other European directives or regulations that are critical to consider, like that of 2019 on transparent and predictable working conditions, because here the key elements of the employment contract are set. So this is what should be considered in analyzing any kind of relationship between a worker providing services and a platform company. Another important directive is that of 2023 related to equal pay and pay transparency. And finally, the regulation from 2016 regarding the protection of data, right? The General Data Protection Regulation, or GDPR, because this is also one of the key elements in this type of work, how workers are protected regarding their personal data, because it's not only personal information, but even through GPS, they are tracked in where are they at every moment in time, right? So a lot of consider from the point of view of European legislation. There are as well ILO guidelines regarding platform work that are more and more addressing the different problems that are coming from this type of relationship, contractual relationship, employment or not. And also important to consider how the courts, the high courts in different jurisdictions are ruling around the regulation, around the employment or not relationship of the workers. There were cases in 2020 in Spain, in Italy, in France, where the Supreme Court in Spain regarding Globo, or the Corte di Cassazione in Italy regarding Foodora, the Cour de Cassation in France regarding Uber, started critical rulings that try to clarify and disentangle the mess in which these workers were operating. Others followed in the UK in 2021, the Supreme Court case around Uber, and then Germany, the Bundesarbeitsgericht on the crowd, and finally some others in the USA, in California, and some Latin American countries, Chile, Argentina, and Colombia. And this list is just illustrative, it's not an exhaustive enumeration, because many other countries are facing these challenges and the high courts are regulating the issues. Some recommendations for legal operators: critical elements to consider: reclassification of workers and transparency in the elements of the employment relationship. The need to follow due process in modifications of working conditions is something critical to address as well. Following strategic litigation processes that will help to clarify their employment elements, and also in particular regarding the modification of the contract, the substantial modification, how to proceed when there is a need to change these conditions. And finally, policy reform. And this will be actually one of my final thoughts. Digital platforms clearly disrupt traditional labor relations, and it is necessary that legal systems evolve to balance the needed flexibility with the dignity and the transparency that must be present in any employment relationship. In this context, a balanced approach should embrace innovation with or while ensuring fairness and transparency, which are always critical elements in any employment relation. And finally, I think it's critical that a transnational approach is followed both in policy and legal development. So more and more transnational coordination and harmonization is needed, because, as I said in the beginning, platform work is characterized by globalization and operating in a transnational way. And this is all from my side. So thank you very much, and open to any question.
Thank you so much, Julian, for such an interesting presentation. And I discovered for myself new terms which are really interesting, such as rights misclassification and presumption of employment. And I'm sure we will talk more about that in our discussion. And now we will proceed to Kateryna's presentation, which will be on digital labor platforms under the Business and Human Rights Toolkit, current regulation and perspectives. Kateryna, the floor is yours.
Can you see my screen? Hello, everyone.
Yes, we see it, Ilya.
Yes, we can see.
Yeah, so basically today we have a nice discussion on platform employment. Thank you for highlighting existing biases by national law regarding the employment relationship and digital labor platforms and the opinion of international law on this. As we know, digital labor platforms have transformed traditional employment models, especially in private sector of economy. They could enable millions of people to work on and through them online or location-based like Uber. And those models spread globally, and significant questions arise about labor rights. And there are a lot of researchers conducted in many countries for more than 100 DLPs, and most of them show that there is an increase of gender pay gap, reduce women's labor market participation in DLPs, and so on and so forth. At the same time, we have seen an increase in non-entrepreneurs seeking to develop labor rights in private sector of economy, including digital labor platforms. This resulted in such significant amount of acts drafted by different public actors with a different level of involvement of labor law actors for consultations, for standard settings, and so on and so forth. Such acts as Amani Declaration as a soft law by ILO conventions as a hard law by International Labour Organization, UNGBs as a soft law by UN, or upcoming initiative on UN treaty on this by UN as a hard law. Also, there are numerous initiatives on a subnational level as a Corporate Sustainable Due Diligence Directive and Directive on platform employment by European Parliament and European Council. There are a lot of ongoing initiatives which are relevant for the topic of digital labor platforms, which are more of general scope like Corporate Sustainable Due Diligence Directive, or with a specific labor law focus like EU Directive on platform employment. At the same time, all of the mentioned tools have significant gaps in the direction of digital labor platforms. For sure, we can benefit from UNGPs and their three pillars, which were mentioned. But there is a common gap, which is fair for all the mentioned documents in labor law domain. All of the documents uses references for the ILO conventions. And they just attach ILO conventions as an annex for the mentioned documents. But there is some issue with the ILO conventions. As usual, the ILO norms in conventions coming back to this picture you probably see and curious, we are aiming to have right to claim in domestic courts under these conventions. And so we are aiming to stay on this side of the screen, but not here. But as for ILO norms, we are in a trouble regarding this. These norms remain to stay with indirect horizontal effect toward businesses. And those businesses are including digital labor platforms as well. For sure, there are some exceptions for some norms which are of self-executing nature, like for the Article 2 of ILO Convention number 87. But even those articles are under considerable debate regarding their nature. So ILO norms are in most of the conventions are often not characterized by the structure that the legal norm A, including rights, obligation, extend or applied to subject M. like some particular scope of actors. And this creates difficult for domestic courts, for companies, for workers. They do not have time for textbook like analysis of those provisions and their nature. And it's complicated to identify the actors for whom those norms addressed and the scope of rights of those norms. Just to demonstrate, as usual, they are of very vague nature. And there is a mistake to link in for these norms in all the other tools because of the following misclassification of labor rights under this. So, what's the issue? There are different categories of norms, and there are binding norms, there are quasi-binding norms, and quasi-recommendable norms. What can be understood under this? Under binding norms, we understand legal rules or standards that are mandatory and enforceable by law. So we have right to claim under this. We also have quasi-binding norms, and they are often used in soft law acts, such as Amania Declaration or UNGPs, and they are not legally enforceable by themselves, but they are kind of binding in conjunction with the hard law when they restated a provision of a hard law, which is binding and enforceable. However, enforcement by them, as usual in the domain of labor law, is very limited. But why? Because we are dealing with ILO conventions. So, as usual, they have a huge list of quasi-recommendatory norms. So, those norms are more of advisory nature, or norms definitions, norm declarations. They might be a part of hard law instruments for sure, and they are important. However, they do not impose any clear legal obligations for some particular labor actors. And they are more of intention of encouragement regarding the best possible practices. So we are not, as usual, having right to claim in court under these provisions. What do we have under the above-mentioned documents? As usual, there are a lot of quasi-recommendations which are used as references throughout quasi-binding norms in soft law. So it doesn't make them binding. Also, there are a lot of quasi-recommendations which are very confusing with the binding norms, and the line between them is very blurry just because of this type of construction. And then we are obtaining Corporate Sustainable Due Diligence Directive, which is just using those norms which do not invoke any right to claim in court under this. And this is a fair opinion of the ILO or of prevailing academicians and also of case practice. And there is an urgent need to consider this for the further and upcoming legislation, because right now ILO will make a decision on the drafting of ILO Convention on digital labor platforms, and it would be requested by the ILO to consider the experience of previous unsuccessful conventions and also to consider the business and human right approach. So now we are focused on negative sides of these documents, and let's move to business and human rights and vice versa. So how could we benefit from business and human right toolkit for labor law? UNGPs, they offer us a clear structure by actor for so whose obligations are. Also, there is a need to create a smart mix of rights and obligation for each particular actor. And this particular actor must have a clear understanding. Is it an abstract norm or is it a precise norm? So is it a self-executing norm or is it something which is of inspiration of best practices? Also, there is a need to structure this upcoming convention, and this structure must give a clear understanding where the labor actor is now and to what extent particularly this or that part of the legal act covers his or her rights or obligations. So that's the UNPGs. Then there is a mini declaration, which is also a soft law tool by the ILO, and the special feature of this act is that it's differentiate different actors and assigned them a specific role. So this lays the foundation for the fair and reasonable balance between the rights and obligation of each individual labor actor for the upcoming instrument. Also, this particular declaration provides a roadmap for its realization under the promotion, corporate union dialogue, and dispute resolution procedure. So, and under this realization procedure, they collected quite a lot of data by different actors, which acts on regional and local level. So it gives a possibility to identify problematic areas of realization of labor rights, and it makes us possible to collect a great amount of qualitative and quantitative objective and subjective indicators of human rights, which might be crucial for the upcoming drafting of the ILO Convention in case this decision will be made. So also, how could we benefit from hard law tools, and how can we benefit from the existing business human rights toolkit for labor law? So, Corporate Sustainable Due Diligence Directive offers us binding obligations for the companies, and digital labor platforms for sure are also companies. And also, under this, we could offer a clear structure for the document and also a clear obligations for each particular actor. But also, if we will consider this drawback, two possible solutions for this can be offered. We could make changes in wording of the rights in this Corporate Sustainable Due Diligence Directive and make them under the criteria of self-executing norms. Or also we could work on the ILO side and to make a revision of its convention under the procedures of these organizations. So, and as for further recommendations, what can be done as we are running from time? What should be recommended for the ILO and its standard setting procedure in this area? So first of all, a clear, not blurred border between binding and quasi-recommendable norms. And the clear structure like it's offered by UNGPs or Corporate Sustainable Due Diligence Directive, where each particular actor could understand its scope of rights and obligations. Yeah, I am open for any questions and for the discussion.
Thank you so much, Kateryna, for such an insightful analysis of how our different regulation consists of practical, paradoxically, conflict between different regulations, yes, and how the referral to, for instance, ILO conventions can blur this difference, yes, and blurs this distinction between binding and non-binding requirements for employees and employers within respect for platform worker rights. And now we can proceed to an open discussion. Thank you once again for all our presenters to providing such amazing presentations. And I have a lot of questions, but let's see, maybe someone from our audience already has some question. Please don't be shy and ask questions. Tatiana, please, you can ask the question.
Thank you, Tamara. Thank you, dear colleagues, for your wonderful presentations. And my question is mostly for all of you, because I have heard the important words like case law and strategic litigation. And my question to you, please share your thoughts how we as researchers, scientists, teachers can help to improve strategic litigation, to encourage and somehow to form this, to unify this court practice and to help the platform workers to fight for their rights. Thank you.
Thank you very much, Tatiana, for this question. Does someone of our speakers want to elaborate?
In my opinion, the corresponding inspection of labor or similar body or institution in every country should lead these strategies and should be a critical agent in bringing into court cases where rights of employees may be in confrontation within these labor platform models. So I think that is one of the key agents to play in this game.
Thank you, Julian.
If I may, I also believe that the role of the civil society shall be strong in those countries where the legal interpretation of the concepts we are explaining is not very uniform. So, for instance, strategic litigation could go in the direction of claiming for the recognition of certain rights, for the recognition of a uniform characterization of the contracts, and maybe in the future also collective actions might be brought in these directions as to push for a broader and straightforward interpretation in this regard.
Thank you so much.
Thank you very much, dear colleagues. I probably, if Tamara allows me, I probably follow a bit. Angelica mentioned NGOs. It's really important to collaborate with them because actually there should be someone who pay for all the expenses. Well, this issue is particularly interesting for me because I led the Department of Strategic Litigation in one of the Ukrainian NGOs for 5 years. And that's why I understood how much it takes to support strategic litigation from the very initial case to the higher level courts. And it was the suggestion probably, can we probably involve legal clinics under the law faculties to participate in this exercise as well? Probably some of you has such an experience in your universities. Thank you.
As far as I'm concerned, unfortunately not, but it would be a great idea actually. I mean, building legal clinics is quite complex from the administrative and procedural point of view, if I may, because you need to establish contacts with tribunals and having access to documents, whatever. So the preliminary building of legal clinics is quite complex, but I think that from the outcome point of view and the students.
Yeah, I think something went with Angelica's internet connection. Yeah, I hope we will have back Angelica to us. Yeah, and
thank you in any case. Yeah.
Yeah, yes. So while we are waiting, yeah, I just want to share also. I think it just depends also on the format of legal clinics, because I've seen different ones, and I was engaged in our national law university. In Kharkiv legal clinic while being a second year student. So I think it's really important also to have senior, very devoted lawyers back there to legal clinics, because students really need to be led by someone who has more experience. And then also I think it's important to include attorneys, for instance, who have the right to represent actually victims in the courts. So actually it can be a really great idea to create kind of maybe partnership between NGOs and legal clinics. So students can take easiest tasks and learn from senior colleagues who are more experienced in that field. Yeah, I hope. Yeah, I think Angelica disconnected, but I hope she will be able to return back to us. Yes, does anyone else wants to ask more questions? Yeah, okay, so then I will raise mine. I also see a comment in the chat from Olena regarding legal clinics, and Olena writes that, yeah, it would be interesting to ask our partner Raoul Wallenberg Institute, because they work a lot with legal clinics also, and have a separate project with them in Ukraine. And my main question actually was to all the speakers, because after listening your extremely interesting presentations, I see this general trend of yes, critiques, really serious critiques to neoliberal business model, which exists now within, I think, majority of countries, that allows businesses to deregulate. Yes, to deregulate the whole concept of responsibilities in labor law and responsibilities towards workers' rights. And actually, my question was, of course, what you see as a ways to address these challenges? Yes, to combating this neoliberal, very deregulative approach towards business actors and employers' attitude towards their workers' rights. And really connected with it, like I found from all of your presentation that self-employment is also kind of a concept that emerged from this liberalization of labor activities. But do you find generally the concept and format of self-employed person more as a negative or a positive tool? Because on the one side, it allows, yes, more free changing and more liberal approach toward working condition. But on the other way, we see how a lot of employers misuse and overuse the format of self-employment, employed worker, then undermining all the labor requirements to respect the human rights of workers. So how do you find maybe how we can address this issue?
So, first of all, I see that we need a fair balance of interests in between workers' rights and companies' obligation. For sure, there is a shift for clearly defined labor rights in the domain of private sector economy. For sure, it's also spread on digital labor platforms. But at the same time, we cannot over-regulate this area. Otherwise, it will be not a bargain for companies to follow these rights. For sure, we cannot violate some fundamental labor rights which were established more than 100 years ago. But at the same time, I see some critical points in regarding European Union directive on platform employment. For example, it make a presumption of employment relationship, what is great and what's a victory of labor law under Article 4 and 5 of this directive. At the same time, this directive doesn't ask a question, what's an engagement of worker for this particular digital labor platform or platforms, and what's the level of this particular platform regarding this particular worker. So this directive under Article 17 requests from digital labor platforms information about working hours, about intermediaries, and so on and so forth, like a huge piles of data. At the same time, this directive doesn't consider these circumstances. So it doesn't offer any smart mix of rights and obligation based on these two criteria, like subordination and time performance of the worker. And I think it's crucial to consider that digital labor platforms, at least, are very different and diverse by their nature. And there are a lot of distinguished features for now we have in labor law domain. And we must consider this, as well as this must be fair for the companies with the horizontal structure of management as well. So they control their workers less, and maybe we need to think about some changes in the balance of rights and obligations to become sometimes less protective and sometimes a bit more protective, and to stay flexible under the principle of subsidiarity when it's needed. Yeah, that's my opinion on this.
Thank you so much, Kateryna. Julian?
I think the key element is reclassification or accurate classification, as we discussed, and Angelica mentioned some court rulings. The point is that self-employed person is a person who decides to self-employ, right? When this self-employment is imposed by a platform or operating company, then it's no longer self-employment. Rather, it's a different thing. It's a false autonomous worker, or whatever it is. And this is the key to define whether the sphere of rights of employment affects the person or not. Is this person truly a self-employed person, an entrepreneur, or is simply a form of precarious work? And also, I think that let me build upon Angelica's previous comment on the civil society. I think this is also a very important element, that unions are not placing that much focus on these labor platform workers, because somehow they are outside of their sphere of influence. We already talked about weak representation, weak bargaining rights, etc. And whether it is the unions or maybe NGOs, civil society entities, associations, I think they should take a leading role in fighting for defining the rights and obligations in this new world of work.
Yeah, thank you so much. And I have two following questions from your input, Julian. And first one, yes, and that is the main idea of my question. So yes, the concept is nice for person to be able to shape their life and work balance, yes, their choices, what they want to perform within their life, but then it's becoming so misused when you apply to the job and your employer from the standpoint says that you need to create self-employment status to receive it, because we will not gonna to proceed with you through our ordinary labor procedure, which is protected by, for instance, Labor Court of Ukraine, bringing a lot of social benefits and a lot of protective mechanism to to employees, yes, and then the question arises: how can we control it, or how can we check it with the business whether it's really imposed on the employees, or it's a free choice and free will to do that? And then the question comes to Angelica's presentation. Angelica mentioned that in the presentation more focus on the second and third pillar of UNGPs, but also what do you find in the first pillar of UNGPs? Yes, how state can here intervene, and how state can effectively provide protection to this kind of issues, or there is no way out for the state, and we have such a developed digital platform regimes that cannot be fully controlled by the state. Yes. It's mainly the question to Angelica, but everyone is welcome to respond.
May? Oh, thank you very much, Tamara, for the question, which gives me the possibility to go a little bit more in depth on the first pillar, which obviously is the key pillar. The preliminary action of the state is extremely necessary as to set up the legal framework which provides for the necessary guarantees to the digital labor platforms workers. Therefore, for instance, the directive, the European directive, which obviously has a certain cons, but has also several pros, which are obviously taken into consideration, and which are a very good point of departure as to implement on the part of the European Union its duty to protect human rights, and on the part of the European member state which implement the directive, again, their duty to protect human rights in this specific field. So I think the role of the state is always the preliminary and the primary role when the protection of human rights is at stake. Therefore, obviously, we all need the states to do their job, which is to behave as the duty holder, the primary holders in this regard. So setting up the necessary legislative, judiciary, administrative measures as to guarantee that the corporations under and the individuals under their jurisdiction comply with human rights, therefore as to avoid the inter-private violations of human rights that might occur within their jurisdiction. So which role? The states shall implement the adequate legal framework, shall implement the necessary judiciary tools, establish the necessary judiciary procedures, guarantee the execution of the decisions, and do whatever they can as to set up the legal framework, which then must be implemented by the corporations.
Thank you. Thank you so much, Angelica. And also the question which appeared in my mind maybe is more practical, but we talked and discussed about civil society, but also it's interesting for me how labor unions, do they at all apply to digital platform workers? Are there any examples where labor union was defending the right of workers, or it's not existing concept within digital platform workers where everything is almost self-employed or under-recognized under labor provisions? Yeah, Kateryna?
Yes, as usual, trade unions are involved, at least for consultations, when some legal acts are in process of drafting, and also they might be involved in gap analysis of current regulation, and yeah, cases like this are pretty spread.
Yeah, it's more kind of consultancy, yes, work. I just was interested whether there are any cases when labor union brought actually, yes, a collective bargaining against some company, or it's not so applicable to digital platform workers.
Actually, it's a space for discussion because not all of collective rights are applicable for platform workers because of the nature of these labor relations. So it's quite challenging to have these rights and to execute these rights as well. So, I mean, those rights are not excluded from the scope of these relations, but it's complicated to make them enforceable in practice, unfortunately. Mm-hmm. But also it's a case of like most of collective rights in private sector of economy. For example, for Swiss courts, the ILO conventions 87 and 98 regarding collective rights have only indirect horizontal effect towards companies in private sector of economy. So for sure, it will be not applicable for digital labor platforms as well by this case example.
Okay. Yeah, thank you. Thank you very much, Kateryna, for the answer. Do we have more questions from the audience? Yeah, I see also a comment from Kateryna. Yeah, thank you very much for placing the state duties under EU directive on platform work. It is really helpful. Yeah, and if we don't have more questions, I think we can really thank our speakers for incredible and really interesting presentations today. And we are very happy that you found time and opportunity to be here with us and to present. And we are glad that all 5 webinars within our Business and Human Rights Spring webinar series happened. And we are very happy to elaborate more and yes, coordinate and make a common effort to spread business and human rights knowledge among different sphere of regulations. Thank you very much.